This police officer arrested a firefighter at an active accident scene, but no charges were ever filed. So, was this lawful or an abuse of power? On February 4, 2014, Officer Eliezer Conga of the California Highway Patrol responded to an overturned vehicle, where multiple emergency units arrived, including a fire engine driven by fire engineer N.M. Jacob Gregoire. At the officer's request, some trucks were moved, but when Gregoire refused to reposition his vehicle, the situation escalated. Officer Sergio Flores arrived, approached Gregoire, and what began as a discussion quickly turned into an arrest. Gregoire was handcuffed, placed in a patrol car, and detained for 30 minutes, then released with no charges filed. Months later, he filed a federal civil rights lawsuit, while Officer Flores claimed qualified immunity, arguing the law was not clearly established. However, the court denied that protection, allowing the case to move forward, raising a powerful question. Was this about public safety or control?
Deputy Attorney General Robert Mrgoyski from the California Attorney General's Office, here on behalf of defendants, appellants, California Highway Patrol, and Officer Sergio Flores. I'd like to reserve, if I may, 3 minutes of my time for rebuttal.
All right, watch the clock.
May it please the court. This is a qualified immunity case, and the court should find that the doctrine of qualified immunity applies to both of the federal claims in this action. I'm going to start today by talking about the arrest claim, and then I'll move on to the excessive force claim, and then if there's any time remaining, I'll address the issue of jurisdiction over the state law claims. So starting first with the question of qualified immunity for the arrest. There are three independent reasons why this court can reverse the lower court, but the most straightforward is the second prong of the qualified immunity test. Here we have two competing interests. On the part of the fire department and plaintiff Gregoire, there was an interest in management of the scene in terms of taking care of the patients who are present on the scene. That's their perspective. From CHP's perspective, there's a very important competing interest in protecting passing motorists who are going by a freeway that's partially blocked by fire engines and by a squad car and by an ambulance from subsequent accidents, being injured or being killed on a busy freeway at night. So we have these two competing interests. And against that, we have a set of state statutes that don't explain what consultation means, and they don't explain which of these competing interests predominates.
Well, doesn't that case, the County of San Bernardino versus City of San Bernardino, kind of outline who's in charge of what in terms of emergency scene operations?
Yes, and the statutes give a general outline.
Clear that the police are in charge of the scene management, but medical personnel are in charge of patient care decisions, right?
Yes, but the specific provision at issue there comes down to Health and Safety Code 1798.6, which says that priority goes to persons exposed to the most serious risk. It doesn't say how you figure that out. Is the most serious risk the patients who are on the ground, who were recovering from the accident?
During the oral arguments, Mr. Rogoyski and Judge Wardlaw discussed key California laws governing accident scenes. Under Section 409.3 of the California Penal Code, when both law enforcement and emergency medical personnel are present, overall scene management falls to law enforcement, but they are required to consult with other responding agencies to ensure proper use of resources. At the same time, Section 1798.6 of the California Health and Safety Code gives authority over patient care to the most medically qualified professional on scene, emphasizing that actions must prioritize minimizing risk to life and health. The California Supreme Court in County of San Bernardino v. City of San Bernardino, 1997, further clarified this division by stating that scene management refers only to non-medical tasks like traffic control and crowd management, while medical decisions remain with healthcare personnel. This clear but delicate balance of authority between police and medical responders lies at the very center of the conflict between Officer Flores and Mr. Gregoire.
This is a case of disputed facts, and I realize that the parties have different stories, but suppose we take this and look at the facts in the light most favorable to Gregor, the non-moving party, and his witnesses, they all seem to say that he was actually attending physically to a patient when he was arrested by Flores.
Yes, but it is also undisputed that, in the words of the lower court, that Officer Flores faced concern about secondary accidents, and there are undisputed facts which establish that Officer Flores talked to the firefighters and Officer Colunga talked to the firefighters, which Officer Flores overheard. So this court takes plaintiff's version.
Are you aware of any other case where at the scene of an emergency, a police officer arrested someone who's attending to someone medically?
I'm not aware of a reported case, and for that reason alone, the second prong of the qualified immunity test applies here. There have been situations, I believe factually, I'm not sure this is in the record.
Don't tell us things outside the record. I'm just saying, is there any other case that, is out there?
We're not aware of any case that has addressed a situation even remotely like this, Your Honor. And for that reason alone, that's a simple reason why the qualified immunity test, for the second prong of the qualified immunity test, to apply here.
Or it could be that it's just such an outrageous thing to do that nobody's ever done it.
So Your Honor refers to the obviousness exception to qualified immunity. This court has recently defined obviousness as conduct so flagrantly unlawful that few dare its attempt. This case defies obviousness because we have a state statute which contains an inherent contradiction. When you have an EMT who's engaging in their duties, and that EMT is arguably in conflict with the CHP officer engaging in their duties, who wins? We don't know. The California state statutes don't explain that. We're not aware of any case law that explains that. So it's hard to say that this is so flagrantly unlawful because there's no explanation for what qualifies as unlawful.
Were there ever charges brought against Gregor?
No, there were no charges brought against Mr. Gregor.
During the argument, Mr. Rogoyski contended that because no prior case law addressed a situation like this one, Officer Flores should be granted qualified immunity under the second prong of the analysis. The two-prong qualified immunity test established by the Supreme Court in Saucier v. Katz, 2001, states that a government official is protected unless the plaintiff shows, first, that a constitutional right was violated, and second, that the right was clearly established at the time of the conduct. Although courts were originally required to address these prongs in order, the Supreme Court later clarified in Pearson v. Callahan, 2009, that judges may consider either prong first, meaning a case can be dismissed solely because the law was not clearly established. Additionally, in Anderson v. Creighton, 1987, the court held that a right is only clearly established if it is defined with enough specificity that a reasonable officer would understand their actions are unlawful, not based on broad general principles. Applying this framework, Mr. Rogoyski argued that even if a constitutional violation occurred, no sufficiently similar case existed, and therefore a reasonable officer in Flores' position would not have known his actions were unlawful, entitling him to qualified immunity.
So going back to the obviousness question very, very quickly, if there were a definition of consultation and there were case law on that, particular case law from the circuit, then we might get into an obviousness zone. Or if there were obviousness usually applied in excessive force cases involving extreme examples of excessive force. That's just not the situation that we have here. And it is an open question whose interest predominates if you have a patient on the ground and someone attending to them, and a concern, which is undisputed and recognized by the lower court, that the next person's going to ram into the back of one of these vehicles that's blocking the freeway and get injured or killed. Who gets priority? We don't know. CHP doesn't know, firefighters don't know, and that's why they're supposed to consult about it. But we don't have a definition of consult either. So how does that get figured out? When we have all of these questions, which cannot be answered.
Consult doesn't mean arrest.
I agree with that. But consult, one regular definition of consult is to seek information or advice from. That's a pretty plain language definition of consult. If you use that definition, that's what happened. Officer Colunga went and talked to the firefighters, asked them to move their trucks. They didn't. He asked them, why are you not moving them? They gave their explanation. under that plain language definition, consultation would have happened within the meaning of the statute. But we don't even have that here. We don't know if that's good enough or not. And a CHP officer in a developing situation on the ground who has to make some quick decisions in the interest of public safety needs to have some discretion to make a decision that we might afterwards say was not prudential. But that's what qualified immunity does. It protects their discretion in these rapidly evolving situations. And sometimes in the application of 2020 hindsight, we may say that may not have been the most advisable thing to do. But again, 2020 hindsight doesn't apply to the situation here.
So Kalunga went and talked to the firefighters, but Flores didn't.
Well, Flores also spoke to Mr. Gregoire, but it's undisputed that he further overheard Kalunga speaking to the firefighters and specifically asking them, hey, why have you not yet moved these fire trucks?
And the explanation was?
The explanation was that they were engaged in patient care, although I don't think that's technically part of the record. I think it can be inferred that it's part of the record.
And that's certainly what Gregoire says, right?
Yes.
And his two witnesses.
Yes. And that is plaintiff's version of the facts. But it's also undisputed that California Highway Patrol had a competing interest in protecting passing motorists from getting into a severe accident.
Why didn't they just get the keys and move the fire truck?
So that's a good question. It turns out the only person who was qualified to move the fire truck, and no one found this out until after the arrest happened, was Mr. Gregoire. Captain Albright himself later said, I believe, around the same time that he was not qualified to move the fire truck.
Seems like there's well, I don't want to go into it, but anyway, go on. How much time did you want to save? Okay, Judge Gold.
I have a question for counsel, if I may. Let's put the arrest aside for a moment, and let's say I assume that there's not clearly established law and someone's got to be the captain in that situation, and so the plaintiff loses. Still, how can it be justified on the excessive force claim for police to put like an EMT in handcuffs, which also were alleged to be two types of, I mean, as I looked at this, it looked like an unusual case of two good guys getting in a dispute, a cop and an EMT. But if the dispute required an arrest, why did the police put the EMT Gregoire into cuffs?
So again, we're getting to the distinction between what is within the scope of discretion and what is prudential. Looking back at the situation, we may say it was not prudential or advisable to put a firefighter into handcuffs. But it is standard practice everywhere during the course of an arrest to place the person in handcuffs. Officer Flores did not know at the time whether this individual he was placing under arrest would behave like a normal individual under arrest or would respond with a substantial amount of adrenaline. So he did the standard procedure, which is to place that person in handcuffs. As to the tightening of the handcuffs, again, the best answer here comes from the second prong of the qualified immunity test. We don't have a case on point which deals with this specific situation, which is, we have to remember two important facts. One is that there was no physical injury. It's undisputed that Gregoire was not harmed. He didn't have any bruises, nothing. The other fact that's important to recognize here is plaintiff says, he asked for the handcuffs to be tightened and he asked them to be loosened, and they were just tightened. That's actually not what the record shows. One of the pages cited by plaintiff, record at 93, is an admission by plaintiff where he asked for them to be loosened, then they were locked, which had the effect of making them tighter. So we have these two interesting features: handcuffs requested to be loosened, but which were tightened to a point short of causing injury, and plaintiff admits they were locked, which is a procedure to prevent them from causing injury. Is it beyond debate that every single reasonable officer would know that you can't do that based on existing law? No. And in fact, there are some situations where a reasonable officer might think that handcuffs, which can be tightened to some point short of causing injury, should be tightened. So again, we don't have a case on point. And this is one of those areas where we might not it might not be advisable to have a case on point, because we're dealing with excessive force in the sense of the minimum amount for excessive force you need to have a viable claim, not an extreme case of an excessive force like a shooting or something like that. And we're getting very close to traipsing all over the legitimate scope of officer discretion. And we want to avoid a situation where the manual of handcuffing procedure is written entirely by the judiciary. So as a prudential matter here, when there's no injury, when we have no cases which are on all fours, all threes, all twos with this, then the safest thing to do is say the second prong of the qualified immunity test applies.
And counsel, is there evidence in the record supporting the point you made in response to my question, saying that all officers put people in handcuffs whenever they make an arrest?
I believe that's there isn't evidence in the record that I'm aware of that I can cite offhand, but I believe that is a well-recognized principle in this circuit's jurisprudence. And I believe it's in the statement also appears in one of the cited cases. I think it's Lowand. I'm blanking on the specific case site. I'm under 3 minutes, so I would like to reserve the reign of my time for rebuttal, if I may.
You may.
Thank you.
Mr. Regoy concluded his argument on behalf of Officer Flores, strategically reserving a portion of his time for rebuttal and opportunity to respond after the opposing side has presented their case. Following this, Mr. Robinson approached the podium and delivered his oral argument representing Mr. Gregoire.
Robinson, I represent the appellee Jacob Gregoire in this case. Your Honor, you had mentioned at the beginning of my colleague's argument that this is a case involving a lot of disputed facts, and I think that's one of the key things that needs to be kept in mind when looking at the district court's ruling here. One of the problems, I believe, with the CHP's argument is that it tends to flow from their version of what they think happened, and they then take that and say, well, under our version of these facts, we're entitled to qualified immunity. But, of course, the opposite is what you're actually supposed to do at this stage. And so you have to start from the premise that we're working from Mr. Gregoire's version of the facts.
My understanding of this is that Officer Flores could still be entitled to qualified immunity depending on what facts are found by the jury.
If I'm understanding your question correctly, it is possible, yes, that the case could be tried to the jury, and depending on what factual findings the jury makes, Officer Flores could be entitled to qualified immunity. But it's also possible that the jury could make a finding of fact where he would not be entitled to qualified immunity,
Right.
which is why the summary judgment was denied.
Point of the disputed facts at this stage.
Correct. Yes, that's exactly true. So I think, the legal issue that they've raised relates to the clearly established part of the qualified immunity analysis. And it was just sort of mentioned in passing in the district court. It wasn't really even made an issue there, but they've made it an issue on this appeal. So I wanted to address that part of it. But I do think because the law and the Supreme Court has continually told us that we have to look at the specific factual parameters and not just sort of a broad brush of what happened, it's important to get a few facts out there from Mr. Gregoire's perspective. The first being that he was, by his admission and by several other people's admission, engaged in patient care at the time that this happened. Mr. Flores, Officer Flores, and maybe Officer Colunga say that they didn't see that, but we take that as true for the purpose of this particular situation. In addition, Officer Flores had placed a flare pattern behind his car, which he had parked behind the fire trucks and the ambulance on the freeway. So he had already established a protective zone behind these to eliminate or at least minimize the risk that someone was going to crash into the back of the fire trucks. And there was some dispute about whether the ambulance was in the freeway or not in the freeway, but again, Captain Albright says that he believes that it was. We take that as accepted at this time. So one of the critical components, which my colleague mentioned, is he believed there was some level of consultation between Officer Colunga and maybe to a lesser extent Officer Flores and the fire department. But the record does not reflect that unless you consider consultation to be, I command you to move your truck. That's essentially the level of consultation that there was. If you look at Officer Colunga's declaration, and that is, I have it in here just a second. That's page 180 of the excerpts of record, and I'm looking at page 183. He said, I had conversations with members of the other two fire crews to ask them to move their trucks into the center median. That's the extent of the consultation. I mean, I know my colleague said he maybe asked them why they didn't move their trucks, and there was some colloquy about that, but there's no record of that. That's not part of our record on appeal here. Essentially what we
Counsel,
have... Yes,
Judge
sorry.
Gould, if I could ask you a question.
Yes.
Along the lines of what I asked your friend on the other side of the case, is there any authority pre-existing, some case law, that says that if we had the situation where one, I'll call him a good guy, an EMT is doing some medical care at an accident, but a police officer, a second good guy, is on the scene and has to try to keep traffic lanes open for purposes of avoiding another accident. Is there any law that says in those circumstances the police officer has to defer to the EMT if the EMT's working on a patient?
There is no case on point on that. I think both sides will agree to that point. What our position is that the statutes themselves are clear and unambiguous in this particular fact pattern. Again, when you're looking at the facts as they are construed in most favorable terms to Mr. Gregoire, because the statutes do require, they say shall consult, they require some level of consultation by the CHP or whoever's in charge with the emergency medical technicians before making some decisions that affect patient care. So there may be some gray areas out there where there was a consultation and there was some disagreement between the people about whether who gets priority, things of that sort. I can see there may be some circumstances, but I don't think this is one of them because there wasn't any consultation. So if you just look at the terms of the statutes themselves, they're not ambiguous on that point. And I don't think you need a case to have addressed that particular circumstance to understand the statutes. And I should point out Officer Flores himself references these statutes as a basis for making his arrest. So there's no claim that he was mistaken about the law or he didn't understand or that they weren't clear and he wasn't sure exactly what he was supposed to be doing.
So your case rests on the shall consult, and your version of the fact is that he didn't consult, and that's a clear mandatory duty under the statute. And the defense is that he did consult. So that's what the battle is going to be about at trial?
That's certainly a big part of it. I mean, I can't speak for them for their defense, but that appears to be the position they're taking. Their briefs suggest that they believe he did what was required under the statute by way of some form of consultation.
Is there any definition of consult, or we just look at the ordinary meaning of consult?
In this case, I think you can look at the ordinary meaning of consult, and in fact, I would be happy to accept their definition of it, because he defined it as requesting information from or talking, getting information from. And again, if you look at the facts, the declarations, there was no exchange of information with Officer Colunga. He didn't say, okay, I have this concern. I understand you all are taking care of patients, but I'm also worried about this other circumstance. We need to work this out. Let's try to figure out what's the best thing to do.
They could have probably had someone else attend to the patient while Gregor moved the truck, if that was
Probably, yes.
other firefighters there, right?
Yes, there were other firefighters there, and
Other EMTs there?
other paramedics there, yes. So sure, they could have made that kind of an arrangement to have someone else take over what Mr. Gregor was doing and have Mr. Gregor move the truck out of the way, but that's not how the facts actually unfolded. Again, just sort of to reiterate, Officer Kalunga, by his own testimony, said, I came over and I said, move the trucks out of the way. They're blocking these lanes. There was no back and forth about information, again, of, I understand there's priorities and let's work this out. Get your trucks out of here. Officer Flores overheard that, and there was no consultation by him either. He didn't say, okay, I heard Officer Kalunga talking to you, let's try to figure out how we can get this done. I'm worried about this. He said, move your truck. That's it.
In response, Mr. Robinson took a different approach, arguing that the California Highway Patrol officers failed to meet a key legal requirement, consultation. Under Section 409.3 of the California Penal Code, officers in charge of an accident scene must consult with other responding agencies, including medical personnel, to ensure resources are used effectively. But according to Robinson, that never happened here. Instead of engaging in any meaningful discussion with Mr. Gregor or other firefighters about patient conditions or the necessity of the truck's position, officers simply issued commands. At the time, Gregor was actively treating a patient, yet he was ordered to move critical equipment without any consideration of ongoing medical needs. Robinson emphasized that this wasn't consultation, it was control. And under the statute, a one-sided order given during an active rescue operation, without inquiry or coordination, falls short of the legal standard required at the scene.
He originally asked Captain Albright, who was also on the truck, whose truck is this? And Captain Albright said, well, it's our truck, and Mr. Gregor is the driver. He's the engineer of the truck. So Officer Flores then knew that Gregor was the person to command to move the truck.
Okay, and what fire department was this? Which city? It wasn't San Diego, was it?
No, the city of Chula Vista. It's a city, South San Diego County.
It's a smaller city.
Correct, yes. This was outside the city of San Diego territorial bounds.
But, counsel, could you at some point please address the excessive force issue? I wondered if you agreed with your colleague on the other side of the case that anytime there's an arrest, it's reasonable to handcuff somebody.
I don't agree with that, and I would challenge them to come up with something that says that's the case. There's nothing in the record, statements by anyone, declarations by experts, anything else like that, that would suggest that every time someone is arrested, they're put in handcuffs. I mean, I'm not an expert in police procedure myself, but that seems unreasonable to me. And again, I haven't seen anything in the record on this case that says that's the way the police normally operate. And in fact, Mr. Gregor said, let's work this out. After Officer Flores said, I'm going to have to arrest you, Mr. Gregor said, can't we just work this out? And Flores said, no, put the handcuffs on him, and put him in the car. And I will note there was my colleague said something about the tightening of the handcuffs, and he referenced one section in the ER, but there's another section, 140 to 141. This is the deposition of Mr. Gregor, where he said, what did Officer Flores do after you asked him if he could loosen the handcuffs? And Gregor said he tightened them. That's page 140 of the ER. So there's clear testimony from Mr. Gregor that he believed, at least from his perception, that the handcuffs were tightened. And we did cite several cases, if you want to talk about clearly established law, there's several cases that say tightening of handcuffs when it's not justified can qualify as excessive force. I don't think that's really a disputed point of law. I don't think you need a specific case that says if a police officer, CHP officer arrests a firefighter and tightens the handcuffs, that can be excessive force. I think you can extrapolate the general principle that that's going to be excessive force in this circumstance. So again, I don't agree with the idea that this is ordinary procedure, and I haven't seen anything in this case or elsewhere that suggests that it is. I'm getting short on time, so the one other aspect I wanted to very briefly address, the state has appealed all of the state law causes of action related to this claim as well, and as we've argued, I don't believe this court should exercise jurisdiction to consider those claims. This is an interlocutory appeal on qualified immunity. It's not an appeal after a final judgment where those things are generally going to be thought of. And the test for qualified immunity and the test for liability under the Bain Act, Civil Code 52.1, or assault and battery, things like that, are different. So resolving the qualified immunity issue doesn't resolve those particular claims. And so I would say, regardless of the outcome on that the court should remand the state law claims. So I believe, it looks like my time is about up. Again, on the qualified immunity, just to get back to the arrest very briefly, I believe the law is clear by statute. We don't need a case that's addressed this particular circumstance. I'll admit there isn't one, but the statute itself says that you have to do this consultation. Again, there may be some circumstances where that becomes confusing or an issue. This case is not one of them. There was no consultation at all. No consultation does not equal some consultation under any structure. So with that, I'll take a seat unless there are any questions.
Curiosity question.
Yes.
CHP is like a state police officer. They're the top guns.
Right.
And
correct.
Fire department was Chula Vista.
Yes, that's
They're the
correct.
little guys.
They are the little guys.
So these are some big bad guy. Police officers use bad guy in the wrong context, I'm sure. They're the head honchos on this scene, so to speak, and that's the way they acted. From your perspective.
Right. Our perspective, yes, is correct. That Officer Flores basically marched on the scene. He didn't talk to Officer Colunga at all. You know, they reference this collective action.
Colunga CHP too?
Colunga CHP also, right. So Colunga gets there first. He tells a couple people to move their trucks, they do. He tells a couple more people to move their trucks, they don't. Flores overhears that. He marches on and says, get your trucks out of here. Doesn't talk to Colunga, doesn't ask them, what are you doing with the patients? How can we get this done? He overhears that and he immediately takes command and says, move, get out, I'm in control. And that's the end. All right, so I'm gonna take my seat.
Clean my robe.
Mine is here. Mine is here.
You dispute his characterization?
Of which part, Your Honor?
Of the CHP being the big guys on the block and they acted like it?
I dispute. Actually, no. I think they do have a different set of interests. I think they do have a different perspective on the scene and the nature of the risk to passing motorists that a reasonable firefighter might have a different perspective on. I think that as between reasonable CHP officers, reasonable firefighters, I think they are going to look at it in different ways. Counsel referred a lot to disputed facts. We're not relying on disputed facts or disputed issues of fact.
So do you contend that Flores actually consulted with Gregor?
Not exactly. We're not saying that he consulted or didn't consult because that would be a disputed issue of fact. What we're saying is based on the undisputed facts, that's Fact 63, Appellate Record 59, Fact 64, Appellate Record 59 also, that he overheard Officer Colunga talking to them.
Right. But doesn't he have a mandatory duty under that one statute that says he shall consult?
Yes, and what we're saying is
Don't you have to prove at trial that he consulted?
No, we don't, because it just has to be clear to every single reasonable officer beyond debate that that was not consultation to lose qualified immunity. Or stated differently, as long as a reasonable officer could
believe that was consultation? Okay, that's what you have to show.
Yes, and so we don't need to go to trial for that.
A reasonable officer could think that ordering the firefighter to move the truck constituted consultation.
Yes, it would have to be beyond debate. And because we don't have a definition of consultation, it's not beyond debate.
You can't use the ordinary definition of consultation? Like just look at the dictionary?
Well, if we use the ordinary definition, which is to seek information and advice from, then Officer Flores overheard Officer Colunga asking the group why they had not yet moved their engine. So he's seeking advice from them, or not seeking advice, seeking information from them, which is the normal definition of consultation. So a reasonable officer could believe that was consultation, whether or not, as a factual matter at trial, that turned out to be consultation. So that's our point. And counsel admits there's no case on point here. Now, he says...
So I'm just curious, because Judge Gold said something that puts this sort of in a perspective for me, which is, look, you guys, your clients are both, they're supposed to be cooperating at the scene of this accident to ensure the public safety and the health of the people involved in the accident. Why can't you guys just resolve this, settle this? I mean, it seems like you're spending a lot of money fighting this you're not fighting for some grand principle here. You're not opposed to each other, really.
Right. So we quote Davis v. Scherer in the briefing, and Davis v. Scherer has a good answer to that question. And if I may quote, the officials are subject to a plethora of rules, often so voluminous, ambiguous, and contradictory, and in such flux that the officials can only comply with or enforce them selectively. In these circumstances, officials should not always err on the side of caution. These situations develop rapidly. It's happening at night. There's a lot of there's patient care going on. There's concern about what's going on in the freeway, and there isn't necessarily an opportunity to have the full, robust consultation we might want post hoc. So, looking at the scope of discretion here, we just have to ask: could a reasonable officer? Is it beyond debate that a reasonable officer could have taken these actions? Well, yes, we have that. We have that situation because there's no case law in point, as they admit.
You don't want this so there'll be some case law on the point, do you?
So this court has discretion to decide the first prong issue as well. Under the first prong, because we say that a reasonable officer could believe that consultation happened, that's all you need for probable cause is a reasonable belief. You don't have to be actually 100% accurate. A more prudential or more conservative way to handle this would be only under the second prong, because as the Supreme Court has warned, highly idiosyncratic factual circumstances do not always create the best law, do not always create the best rules.
Okay. Counsel, I have a question for you, and I guess my question would go to your friend on the other side of the case as well. Is there any chance here that if we deferred submission in the case temporarily to let both parties decide if they both wanted to mediate voluntarily, that this case could go away? In other words, would your office want us to give that option to the two parties, or would you prefer that the court gives you a ruling that says when there's a dispute between police and fire personnel, one side or the other wins?
Your Honor, we are always interested in taking advantage of ADR options when they may produce a result that's more efficient and in the interests of the people of the state of California. I have understood prior statements by counsel for Mr. Gregoire to state that they would not be interested in getting rid of this case unless there was a certain very public, very transparent sort of rulemaking activity. They may have changed their perspective on that. That's what we've understood from
Judge Gold is talking about referring you to the Ninth Circuit Mediation Unit. Have you been contacted by them to mediate this case yet, or?
So I'm actually not sure factually the exact circumstances what happened with the mediation procedure there, because I came onto this case recently through a change in counsel. So I apologize for not knowing that, Your Honors. I will again state that we're always interested in ADR options. I don't know if they contact the parties in every case or not, but your side would be interested in mediation, I'm hearing, if Gregoire was also interested. Yes, Your Honor. And yes, so to be specific, deferring the decision here in favor of giving us an opportunity to mediate, yes, we would be interested. If that doesn't happen, we remain confident that they admit there's no case on point. There's no case on point that decides the second prong of the qualified immunity issue.
Okay, thank you.
Mr. Robinson, would you be interested in perhaps participating in mediation before our mediation unit?
I believe so, Your Honor. I'm perhaps not the right person to ask about that. I'm principally the appellant lawyer, but I do understand kind of how the case has proceeded. And it is my understanding that there may, I can't disclose too much in the way of settlement discussions. I understand there have been settlement discussions, and there may have actually been a mediation already. I'm not sure. It was our understanding that the case essentially was settled, and again, I don't want to represent something that may or may not be correct, but it's my belief at least that the CHP is the one that has pushed this appeal forward. We're always interested in settlement talks and trying to make this go away, and I think we've really tried to do that before having to go through all the briefing and everything else like that. I don't know what the appropriate process would be at this stage, but yes, I think we would be happy to accept deferred briefing or deferred ruling.
Counsel, I think the normal type of order that we enter in some cases would be an order to the parties that would ask them to advise if they both wanted to mediate, or we'd have the mediation office contact the parties, and we'd say that submission was deferred until the parties had time to respond to that, and that if they wanted to mediate, then we'd defer submission until the conclusion of the mediation.
I believe that'd be absolutely appropriate, yes.
And then whenever we knew that it wasn't going to be mediated, then we'd proceed to develop and issue an opinion.
Yes, Your Honor. We would be open to that, certainly.
Okay.
All right. Thank you very much, counsel.
Thank you, Your Honors.
Gregor versus CHP and Flores is submitted, and this session of the court is adjourned for today. Thank you both.
After the oral arguments, the case didn't end with a dramatic court ruling. Instead, it was sent to mediation, where a neutral third party helps both sides try to settle the dispute privately. A Ninth Circuit mediator stepped in, and rather than waiting for a final decision, both parties chose to negotiate. On June 14, 2018, the case was officially dismissed after they reached an undisclosed settlement, meaning the court never ruled on the key issue of qualified immunity. While this kind of resolution is often faster, cheaper, and less risky for those involved, it comes with a major downside. It leaves important legal questions unanswered. In this case, there's still no clear legal standard defining how much. Consultation is required between police officers and emergency medical personnel at an accident scene. And that's the real takeaway here. The conflict was resolved, but the law remains uncertain. Cases like this reveal a bigger reality of the legal system. Sometimes, the most efficient outcome for the parties can leave everyone else without clear answers. So, where should the line be drawn between authority and medical responsibility? Let me know what you think, and subscribe for more courtroom breakdowns.